You don't have a democracy. You can fool yourself. And this thing is not about power. It's past that point. So when the committee was formed to draft this constitution, I headed the delegation from the Liberian Association in the Americas to prepare a proposal for the Constitutional Committee. And one of the key points that was highlighted was decentralization of power. Power was highly concentrated in Monrovia. So, in those committee meetings, as Professor Banks said, I mean, you can condemn whatever role he played, but he was, as a research coordinator for the whole body, he was the one that put the document together. When they had a draft, you would give it a bigger flavor. I was here. I worked with Winston Tubman, do some of these things. But what I want to say here is that 43, 71, 73 are based on our experiences as a nation. The framers of the Constitution for the new republic, in which you are now the senators, intended to do away with the past. You can imagine there was one party here, one political party, and the standard bearer of that party was the president. The president. Whatever the president desired, he called the party chairman, they go to their caucus, that's how they got out. We know what happened to see about me, see about me, yourself. That old man talked to me. Some of us had occasion to talk to some of these old people. In the 1985 election, see about me, yourself, call me. And he told me, say, my son, I've been watching you, and you do your best. But y'all try and bring those boys together. Bring Bacchus Matthew, you bring a Tipoter, family, so I bring all your son. We don't want to see these managers must continue doing this country this way. You're trying to put democracy in place. A technical committee was set up. I heard that committee. They have a meeting in Virginia. After 2 weeks, all the points were agreed except one. What would be the name of the resolving institution? UPP and UPP disagree. That was the end of that. The chaos ensued. And so we ended up with election 1985 with a decree 88 in place. Decree 88 is what drove me out of government. I was Solicitor General at the time when the decree. I advised the government. They refused, so I resigned. I resigned from the position of Solicitor General. My colleague Michael Wright knows that. He can testify. Among the two things, Justice Wright and I are the ones who have said on that bench. So we know what it means when the issues come before the Supreme Court. He knows, I know, we've been there. The court is not there to make regulations. The court is not there to go and look for cases. The court is there to hear cases brought to it by citizens. Because in the Constitution, the people gave certain power to the government for the purpose of security and development, but reserve certain power unto themselves, in which area even the government cannot transgress. That is why when the government wrongs its people, the court is there to say, no, this is wrong. Yeah, this is right. That's the role of the court. The court is not there to take instruction from any branch of government. That is why the Constitution is very clear. The only way that is possible is when the court is above all the politics my colleagues are alluding to when they say impeachment is a political process. I have a fundamental disagreement with that. Due process is not political. He knows what it means. They know it. Let me tell you what, I got one problem with my colleagues. I don't have a problem with anybody here. I don't have a problem with in the executive anyway. I got a problem with the lawyers. Because you know what? The Bible says the lawyers took the key to the kingdom. They not enter, they didn't allow anybody else to enter. We are the ones that can spot it, then we say we can fix it. Don't spoil it. This case is simply using Justice Janet as an excuse to take everyone back to the dark days of the one-party system, where due process was ignored and considered as political process. The Constitution is very clear. Not only one provision, it says due process. You should make rules, prescribe rules in accordance with due process. And what is due process? Thank God that even though we are not don't have legislation here, even the rule 63 they have refers to the criminal procedure. That law says that anyone who is accused of wrongdoing is presumed innocent until he's proven guilty. But my colleague instead proceeded on a path of scare tactics. They didn't argue law here, they argued scare tactics. If you acquit the man, you create problem on the So, Kabineh Justice, I'm sorry. When Chief Justice Kabineh go on, everybody will give away. I don't know that history of going to the Supreme Court. I've been there 38 years, in fact 39 years now. I'm not saying that. That is an excuse to escape the real issue. And my colleague has outlined what those issues are. He said the man stole records of the house. The plenary of the house, and the procedure of the plenary of the house classified is a secret meeting. No, it's not. It's a public gathering. And our Constitution is clear on the fact that the people have a right to know. Not only about their government, but about its functionaries. The people have a right to know. So why make that particular document so different? But interestingly, they themselves could not establish how he got it. The question was asked, how did he get it? They don't know how he got the record. Is that a ground to convince somebody, some people? Is that the reason why the entire Senate must be convened? It's not fair to the people. That's the wrongdoing here. To come up false charges against people just to convict the entire Senate. You know how much is costing the Liberian people for this thing we're doing here? That's the wrongdoing, actually. The lawyer who has deceived the Senate, the House of Representatives, into convening a session of this nation, are the wrongdoers. Because they know. They know. They know. Policy and the policy have been repeated here to say, legislature, describe rules of Amen. I'm not talking to the other jurors over there where people can speak. Over there, the court doesn't have idea who the people are, they have rap. So few of them become. Some of them, when we find out that they don't even know how to read and write, it's qualified. The only requirement to be a juror is to be able to write sentences. You don't have to write that kind of thing. And the lawyer will not be qualified to serve as a juror. But this is the Liberian Senate. So I have a right to expect very hard performance to this body. I have most of you can be. And you ought to oath to uphold the laws and the Constitution. How dare you go back to the grave and say that man should be impeached? On what ground? Can you explain that to your children? Can we explain it to our children who are watching us on Facebook? The day and the night, yesterday and anymore. And not to be part of time. This is multi-party democracy. And that is why the Constitution makes it very clear that in 73, no judge, Justice of the Supreme Court, should be subpoenaed, should be arrested, detained, otherwise. Proof-based conduct. What is proof-based conduct?
Excuse me. Journalists, you have the right to share my light, but it's coming straight in my
Yeah. From 1986. From 1986. And this has been repeated here. From 1986. We failed. And I'm not only talking about you in here or us. Because we elected you to be in here. We should have brought you under pressure to pass the law. We didn't do it, and so you went to sleep. How can you come up now and say, well, I was sleeping and we didn't pass the law according to the Constitution, so now we're saying we're going to convict you? On what law? How? Can't do it. There's nothing you can hold on to. And what is worse, their house, by its own internal rule, such a rule one side instead of an ad hoc committee, and they want you to judge our citizen here, our brother here, our son here, built on the basis of the decision by ad hoc committee set up by the Speaker. Are you bound by the decision of ad hoc committee set up by the Speaker? Does the Speaker demonstrate respect for the procedure of the House? There's a standing committee on House on the judiciary. They bypass that and stand on it. Handpick their own people to come up false charges and say you should validate it. How do you usually deal with that kind of judgment? You can't. You cannot. You cannot. We cannot. My police says when you vote acquittal, you're inviting chaos. Hey, I know you, man, but I can beat you. I know him very well. You know me. Yes. The politics is in about it. Up to now, Justice Janet is sitting and behaving like any other justice on a bench. Nobody has heard that there is some kind of friction. When the 5 justices, and he can testify to it, Councilor right here, meet in a Robin room, only 5 of them sit there. I want to see what I tell you about the Supreme Court. Only 5 of those justices sit there. I have been there, he's been there. What they decide there, the one that you know, when they sign those judgments, they do discuss the cases, the briefs, the arguments that are made. They take note. Those people take note of them. They are like in school. When they go home, they don't sleep. I don't need to sleep and not they take a nap and wake up, they read those notes and research it. Those 5 people are overwhelmed, especially in our system where everybody has a right to appeal. They are overwhelmed. They don't have time for fussing at each other. Professor Banks, for me, outlined the case. I cannot do anything better. In the absence of the performance required under Rule 43 of the Constitution, Section 43 of the Constitution, mandating us to pass through the procedure, I think that has become an urgent matter. As I said, that has removed the case from the head of Justice Janet to our heads. We do the Constitution that we wrote is still to pass law. We have failed. So the first thing we need to do is go back and do our homework. But that's another thing it says so. You can't pass a law today to catch somebody for something done yesterday. There's a history for that. You can't pass a law for just some people. In recent history, you remember all of us heard during the election of 2017, a law was passed by the House of Senate and the House of Representatives that barred the executive governor of the central bank and the members of the executive board of the central bank from contesting or taking part in the political process. Councilor T.C. Gu and Adelaide is so ready. Fire a prohibition. It is in the Supreme Court. In the Supreme Court, fire a prohibition. Challenging the constitutionality of that on the basis of what? Ex post facto and bill of kingdom. The conference was called conference was called. In that conference, the issue was settled. That case died. The next thing we heard was code of conduct. In that code of conduct, there are certain things there that were in that act. But the difference is this one applies to everybody. It's universal. But that one only applies to the executive governor and members. Because some people didn't want, some politicians in the Senate and other places, they didn't want June to run. So maybe you don't like him. But that's not the law. You gotta go by the law. So today, that law is now on the spot. And when the Supreme Court wanted, so today, when the same Constitution says a justice of the court, even a judge, cannot be questioned. The only question that I think we need to be looking at here is whether they as to the petition, the real petition, the real petition, whether the justice acted otherwise. Nobody has brought any evidence of that. He was just in the chamber, and they filed a petition before him. That's the road fund. After conference, he issued a rate, filed it before the full bench. Now let me say something. When a justice in chambers forwards the matter before the full bench because of constitutionality, that justice is asking for a speedy resolution of the matter. He's not delaying. Because if he were to issue the rate and order the party to appear to argue, then they will have to come prepare by their briefs and argument. He will take time to write opinion. That takes a process. From there, another party may still appeal to the full bench, which all takes time. Instead, he said, look, this issue involving national resources, money and things, I will go to the full bench, where the entire court will sit down and look at it. He said they might get it wrong again. What's wrong with you? What is wrong? You know, it's funny, but it's serious. I mean, we really don't have anything to do with this place. People are laughing at us. We should be going to the new government and say, look, that's how we move forward. These are proposals. This is not to say how we can impeach people on false charges. Now we talk about the issue of constance. One thing I just want, because it's been touched, one thing I want to say about that is, look, I saw my grandmother all the way to past that age. And I heard what she told me all these years. I'm sorry I was not able to pass. Okay? Justice Janet, regardless of what other profession he had in 1996, he was not on the Supreme Court bench. He could not have used or misused judicial discretion. So that case should be thrown out. And when you move that out, the fact that he was not a justice of the Supreme Court, you realize that then the issue becomes private parties transacting business. Or some sold the land. He had the authority of the probate court. Up to this hour, nobody has filed a petition to cancel that deed. The deed is standing. So why are they trying to? These are lawyers who know what to do. But the innocent buyer, I know about Kabineh Emptor. Buyers beware. It does not really only relate to property. Anything if you buy used car, anything, you have to be careful. That's how they go back. Kabineh Emptor. Kabineh Emptor. He bought the land. I don't know how he got the information. 1996, $3,600 for half that was a lot of money. People were leaving the country. People were taking their money out of the bank. Nobody had confidence in this country to invest. This man had confidence in this country to say, I will invest my money. He checked the property. They had an authentic document for the probate court. Where is he supposed to go? When the court says, yes, this man can sell, will you say no? You will impeach him 10 years after? Gentlemen, this is not fair. So, 22 years after, I'm sorry. From 1996 to 2018, my people, it's 22 years. 24. And the deed is, there is no attack on the deed. In case somebody here who does not know, if somebody buys property illegally, and the information comes to the proposed owner, you have a remedy to proceed to court to cancel that deed. This lawyer who brought her over here have not advised her already to go cancel the deed. Instead, Honorable Akara Brain himself told you that he went there to the owner. He didn't tell her all the discuss, but from that time he wanted us to pay. Now, it's not clear why he was buying it for himself. We don't know. Could be buying it for himself. Have that. Unfortunately, the man who's supposed to be the buyer who was accused, they didn't even care to see him. They have married the man what they wanted to do. All he wanted was the property. He wanted the property. But he should have consulted Councillor Wright maybe to say, what can I do? Councillor Wright would have told him, look, let's proceed with cancellation, cancel the deed first, then you can go and buy. But when I cancel the deed, can you attack the buyer? Who has bought pursuant to the order of the court? Is that a ground for impeachment? No. That's not an impeachment offense. It's not an impeachment offense. Okay. Now, the prosecution, I'll call you prosecution because in fact you're a prosecutor here. So the prosecutor here, apart from the impeachment, real impeachment, which has been attached sufficiently, the defendant appeared and exonerated himself on all the charges. Because as the road fund, the Constitution is a defense. As the petition for road of prohibition, the law is a defense. With the Constance case, the law is a defense. Probate court gave order to, the man was 40 years old when he sold the land. 20 years later on, you say the guy who bought it was going to impeach him. Suppose you had not become Justice of the People, what were you going to do? What would you have done? Then becoming Justice of the People is a coincidence. Gentlemen, wickedness will not prevail in this country anymore. Wickedness must die. That's what brought us here. It must die. You know, some people here among the colleagues try to question the credentials of Justice Banks. You know, there are some things we need to know. People who have made sacrifice for the place. It was Justice Banks and the only two Liberian lawyers who were in Yamoussoukro, mandated by ECOWAS. Mandated by ECOWAS to establish a unified court system in Liberia. Justice Banks and in Ghana during a conflict, and we came out with the Supreme Court, which was held by Justice Pearson. And the nation was reunited. This man has a requisite experience and training, and he told you after graduating from the Louisiana Grand School of Law, he even went to Yale University and got a master's degree in law. Just like my colleague here, Councillor Sherman, went to Harvard and got a master's degree in law. He didn't stop there. He has practiced, he showed you the various areas of practice, which qualify him to speak the subject matter. Most of the time, it was things that he actually personally knew about. He knew about the JR, the Journal Resolution that was used, that have been abused against innocent people. The case of Witherspoon, all kinds of people. Witherspoon, Joe Philip. So the author, when he said that the drafter, after the drafter, it was submitted to a committee which started in Ghana, where all the countries are represented. They made the changes in there. And put it to a referendum. We voted on it. I can't agree with lawyers who will come back and say, let us follow the Constitution that we wrote. It's too soon. And it's late. I'm glad that we got some lawyers in the Senate in case there's a need for legal opinion after we leave. I see one of the lawyers on my left hand side, I can't call his name. We can't do that. We can't do that. The question of the evidence of the defendant. The law in this country is that when somebody makes an accusation, he has the burden of proof. And the standard of proof in this case, even based on Rule 63 as revised, is proved beyond a reasonable doubt as per the criminal procedure law. The burden of proof does not shift, but there is what we call burden of rebuttal. The burden of rebuttal shifted to the defendant. And when the defendant took his stand, he made a counter-attack, refused the false allegation, and made counter-attack. They have not denied it. They didn't deny anything. And what does our law say? When an allegation is made, this is 1 SCL section 9.8 of paragraph 3. When somebody makes an allegation to which responsible pleading or answer is required, and there is no such, it's presumed to be true. How could you even give notice to do expert witness on the officer? They failed to do so. So we can't put Justice Banks' opinion into question. There has not been any rebuttal. And what did he basically say? To me, he gave us a historical perspective as to our Constitution and how we got here. And some of us can testify to some of the things he said. We can testify to some of those things he said. But so why are we pretending? Why are we pretending? He said all the parties in the other case were all from Niba. Hey, I'm not from Niba, but most of my best friends are from Niba as well. Niba is not different from any place in Liberia. The only thing I know about Niba is that one thing I know about other things that they produce. Niba is one of the producing countries in this place. When I go to Niba, I don't care bag or right behind me. I don't even care plenty. When I get there's surplus plenty, there's surplus anything I want to eat there. That I know. So what makes the fact that the coincidence that in Mrs. Constance's case, including my colleague, everybody was from Niba. There are cases that mean all of them from Lofa. But that doesn't change the truth. It does not change the truth. The question of the withdrawal of the case from the Supreme Court. Amen. Why would my colleague argue this point? He had witnessed some of them. Justice Wright, Justice Michael Wright, Counselor of Law. When somebody files a petition before a judge or a justice in chamber and is being proceeded with, as in this case was found at the Supreme Court before bench, case was argued. While Supreme Court does not get to decide the case after you hear the argument. One judge will be assigned to deliver the opinion. He has to go do research, then circulate a draft to all the other colleagues. They will really contact check the research to make sure everything is correct. After that, before they can deliver it. But the law is that during that time, during the time that the court is considering, if the parties come to an understanding, they have a right to withdraw. Because one thing, the court all over the world these days, and even before, encourage settlement of parties. When you settle the parties, no party gets hurt, nobody is put to shame, everybody is safe. It does not provoke conflict. And so the court can say, well, we got to go ahead and hear the case, we have to go and make a decision. The Roman case went to the full bench. The full bench had an argument. The lawyers filed their brief, they argued their case, and they were sitting for it. Then the parties went and negotiated among themselves and made a stipulation to withdraw. Now, who are these people? Who are these people? Professor Banks told you. Ministers, directors of public institutions. They were not people who were not schooled into the subject matter. They are Minister of Finance, Minister of Justice, all these people appear and sign papers saying we will withdraw the case on behalf of the government. What are justice supposed to do? No, we hear the case and we got to make a decision? No. My approach to the practice, which most lawyers is to avoid judicial decision on issues. Because when the court speaks, it is law. It is law. Look at the Arthur Nyambo case. Arthur Nyambo was president pro tem of the Senate. The Senate moved in. He went to the Supreme Court. Supreme Court did the thing, okay, and we know how that ended. So let's leave our court out of the politics. And the reason the Freemans decided expressly that the Chief Justice should preside over these proceedings. It's precisely that, to take away the elements of politics. Elements of politics in Africa, we know it. It's corrupt, I'm sorry. They got no rules. There's no game, there's no rules of how you play the political game. You can bribe, you can do anything in the night, anything like politics. But that cannot happen when you have the Chief Justice of the highest court in the land presiding in the case. You say, then it's a political. No, he is not a politician. And he cannot preside over a political process. I disagree with my colleague here. Mike, I don't agree with you. You cannot reduce a forum in which the Chief Justice of the Supreme Court presides as a political process. I'm sure you don't agree with him. Because they wrapped up that they want to say here, we're not going to let it come in town. If we leave out the obligation to draft rules and procedures to go impeachment and convince somebody, my people, how can you defend yourself tomorrow? And you know, when those who were talking, I told them decree AA, and it's a serious law. It was basically a form of the Treaty and Sedition law. Okay? But the difference in it was that it empowers security agents to arrest and detain anyone without bail who is caught lying against the president and officials of government. That power was too sweeping. And I wrote a memorandum, I want to give it. So they can do it. I'm sorry, I cannot present. Because Solicitor General is basically a chief law enforcement officer. My colleagues are also being a Solicitor General, so you know what I'm talking about. So we can't come here and pretend that we are disagreeing. We don't disagree. It's just that for some of us we are on the right side. Some of us are on the right side. And that is, when you don't have the rules of procedure, you can't impeach. You can't. You impeach somebody without rules, you will not sleep. And the Senate, I'm glad my colleague referred to you as the elders. Let me refer you to another story in the Bible. It's a song of Solomon, became king. But when Solomon became king after his father David, David had taken Jerusalem and established Zion. He wanted to build the temple. God said, look, now it's time for you to rest. Someone after you will build my temple. Solomon came in and he built a temple, but in the process, people had to work hard, people had to be taxed with money payment, hard work, everything, to build a temple. So when they built a temple, it came to pass that Solomon was no longer a king, and his son became king. He was insisting on imposing the same taxation, the same burden on the people. And the elders went to him and said, King, we understand that your father had to build a temple. That is King Solomon. So he had to tax us. But now you don't have to build a temple. In fact, we think you should lessen the burden of the Israelites. When the elders left, the young people came. So, man, king, the people don't want you to enjoy the same thing your father enjoyed. In fact, we think you should impose more. And listen to the young people who have now had a taste of life. And what happened? When they left, and someone insisted to listen to the young people, the people asked the question, what part we have in the house of David? What part we have in the house of David? A rebellion went on. Up to today, Israel was divided. That is how we have Samaria and Judah. And eventually what happened? A foreign power was raised to overrun Samaria. So then the Jews are scattered about the face of the earth. Because the king, or the son of Solomon, did not listen to the wise old people. These are the hours in Liberia. Even when you are young, you should think old. Just yesterday, we were in Accra, bringing foreigners to help us solve our internal problem. And I remember The same Justice Janet was one of the people who could not sleep, running around trying to rally up how to bring peace back to Liberia. So, what comes to mind is, what does it take to really enjoy life in Liberia? When you reach an age, when you reach old age, and you look back, you say, yeah, we fought for this, and it's working. You know you can live longer and happier. But when you can't, and the very fundamental things that we all suffer for and fought for, how many political parties we got in this Senate? Now that one. So even though you have one president, but there are a lot of political parties who the president cannot ignore. So their concentration must go on. That's the whole idea of bringing people together in one house. And to make it even more democratic, when the House passes, they stand up for review. So, my people, I told you I was not going to talk too long. Hello. The lawyer who filed a petition challenging the constitutionality of the impeachment is now the Minister of Justice. What will you say? You're going to impeach him? I'm going to impeach him. No? Yeah. Are we going to go on to impeach him? So, in closing, we say, first of all, there has been no evidence. I mean, Honorable Carlos Gray, with all respect, didn't convince me that there was any serious case for which the Liberian should be sitting all this time. There was no evidence. My own son, Councillor Kanye Wessel, so about problem I see this young fellow coming up as councillor, comes up and say, well, due process starts in the Senate, that's not fair. And I'm going to deal with him when I hear myself, I deal with that. As former Minister of Justice, I insisted that due process starts from the time the police come into the picture. From the time the liberty of an individual is questioned, due process starts from there. One of our senators here is a former director of the CID, he's not a lawyer, who can understand, he understand what I mean. So when the policeman goes arrest, you have a right to counsel, to remain silent, and anything you say will be used in court of law against you. Those are the fundamental elements. And not all. It also talks about open trial, access, the right to a confrontation, all of that. When somebody testifies against you, you're also here, you have a right to question that question. We did that here. And you have an opportunity as senator to even question with respect to doubts that may have come about. And none of the answer brought evidence that he abused his discretion while serving as a police officer. When he brought the name, he was not there. He wasn't there, so you have to throw that one out. The Rogan case, he said it's in the full bench. If you want to impeach somebody, impeach the whole bench. He didn't understand. Then the people went and said, okay, look, this year we don't want the court to make a decision. They are arguing. They knew what the court did. I know they knew what the court was going to do. Because all the justices in the chamber were saying, look, if we now have an idea as to what the tariff should be, go back to the legislature and get approval. What was so difficult on that? This is an issue that they consider important. They consider it so important that somebody else must be impeached. But if it's not important, ask yourself, why did they come back to the legislation? Until, according to Professor Bank, when a new government came in, then I go to the speaker and say, look, we need to do your meeting. I understand that approach is all that thing is all wrong. So we could have done that for all the days. So that's not an impeachable offense to say, look, this case involves constitutional matter, let it go to the full bench. And what is wrong about that? That's going on every day. Nobody has ever been impeached for doing that. Look at the records of this the Supreme Court. No. Yeah? Nobody has. The Constance case, we said, is not an impeachable offense. nothing was done wrong. Remember that he went out on the bench, so you can't impeach him for that. Petition for constitution, he filed it, any other person. I myself, I had a case in court when I was on the bench. The only thing is I could not represent myself. In this case, the public works minister, yes, the public works minister, all the people who are responsible, who we have confirmed in the Senate, as people who can transact business on behalf of the people, approve. So look, we have settled with these vendors, we are satisfied, so there's no need for case again. There will be other case, then he said they will be impeached for what? It's not fair, man. If it's not fair today, it will not be fair tomorrow. So, we have said again that the law is no rebuttal on the records. There is no rebuttal. That means everything we have said is true, at least by presumption. And my colleague explained what is presumption, constitutional right. Presumption of death, presumption of legitimacy of marriage. Those are statutory presumptions. But the other presumption is that when an allegation is made and has specifically denied for which a responsibility is required, it is presumed to be true. So there is not a choice of whether or not this thing and they are right or wrong. They are wrong. By operation of law, they are wrong. Justice Daniel must be acquitted and allowed to go back to work. Then we redeem Liberia. Some of us can walk out with our head up high. But to compare it, man, just because few people go down there, even the house, look at the statistics in the house. I think there were 23 people there, all 73. Some kind of number was down there. Some kind of number was. And the whole NIBA delegation walk out. That is not easy to get deep, to get politicized. One whole sector of the country was agreeing. And you gotta rescue the situation. We cannot allow the speaker or any individual to set up our committees to circumvent standing rules of the House or the Senate. We can't do that. This whole thing here is out of order. There is no legal memory in it, both as to facts and law. Nothing in it to warrant impeachment. On ground, they have not produced any evidence. They have no rules of procedure. So, what can we do? What can we do? What can we? And the strange thing is, in 2019, one of my colleagues here, especially on my right hand side, are practicing law before International Tribunal, ECOWAS Court. The sovereignty we had some years ago, we no longer have. It's been questioned in many ways. So the whole world is watching us. It's not just our thing anymore. We got to call it the thing. I don't know how many political parties in here, but that tells me that our democracy has come a long way. You senators, I want to congratulate you. You are among what the Liberian people are chosen from among all the hundreds of people who want to be in your seat. You cannot trade it. The confidence of the Liberian people in this country cannot be traded for any artificial value. It is absolute. You took oath to it, so you must honor it. The honor with some kind of procedure.
Wasn't forgotten.
I'll preside. Support and the distinguished juror. I will start up with my presentation by first making few observations which I believe are very much fundamental and critical to this matter. my role as a listed and certified counsel of the International Criminal Court in the European Bar is that when I'm involved in a matter, I must speak to the facts and the evidence adduced, and not vacillate and bring about politics. I'm not a politician. So I have come this afternoon to speak to the quantum of evidence that the House has adduced at this trial. Then, create your indulgence to convict Kabineh Mohammed Janet, aka Justice Kabineh Mohammed Janet, for the fact that he is absolutely unfit to be Justice Association.
You're not according to the point. Can I declare justice unfit in a conclusion of fact?
That's my opinion. You're not. I listen.
You say that he is fake. You are proving not fake. You know, that's the essence of the argument.
That's what I'm saying.
That in his opinion, is not fake for the Supreme Court justice. You went there and said, in your opinion, they have produced nothing to convict.
Thank you, Your Honor. Both by the ECOWAS, AU Court, and the International Criminal Court. Your friend is on the stage, and I'm glad that Professor James and Professor Banks were the one who made all of these recommendations. When your friend is on stage, you don't think that's not proceed. Thank you. I maintain that impeachment proceedings are political, not judicial. And I disagree with my colleague. For example, the strength of my argument is found in Article 43 of the 1986 Constitution. Article 43 clearly and distinctly defines the role of the Honorable House of Representatives as the grand jurors, and the Honorable House of Representatives as the trier of fact, they are trial jury. Due process begins at trial. Due process does not start in the grand jury room. On our criminal procedure law, for example, Senate Rule 63, subparagraph 7 and 11 clearly states that this process is governed by the criminal procedure law. And if it is governed by the criminal procedure law, which the Honorable Supreme Court has passed upon, and Justice Janet clearly and distinctly stated that wherever decision the Supreme Court gave, interpretation is final. That finality power under Article 66 of the 1986 Constitution can be questioned. That having been passed, it means the House of Representatives as the grand juror, due process will not begin for them, but rather at the Liberian Senate. And clearly this is supported by Article 71 of the 1986 Constitution. And I will read Article 71. Article 71. The Chief Justice and Associate Justices of the Supreme Court and the judges of subordinate court of record shall hold office during good behavior. They may be removed upon impeachment and conviction by the legislature based on proved misconduct, gross breach of duty, inability to perform the functions of their office. That's that. The second phase is or conviction in the court of law, or that conjunction or is a succeeding sentence. Meaning the authority to impeach clearly rests with the Liberian Senate. The all conviction refers to the court process. The Honorable Kabineh Mohammed Janet, aka Justice Kabineh Mohammed Janet, committed egregious impeachment offenses, and we will cite them. We will use their own time. My colleague came up and said, "Where is that rule? Where is that rule? Where is that rule?" But let me respond. There are precedents in this place. For example, Senate Standing Rule 1987 was used to impeach His Honor Chair Chipo. That rule was amended in 1998, was amended in 2009, and recently was also amended. That is the precedent. There is nowhere. Now, to suggest that there are no consolidated rules, and so therefore there can be no impeachment, is to suggest that you are questioning the impeachment of Chair Chipo by the Senate standing rule. Now, when they talk about the legislature as using Article 38, and I'm surprised that many of our colleagues, as small as this book, they can't remember most of the provisions. But let me tell you, on Article 43, when they talk about the legislature, the intent of the framework is found in Article 38. Under Article 38, each of the branch of the houses is under obligation to draft. There's only one exception. Only one exception when it comes to the issue of finances that is required. But that rule that is done by each of the branches of the houses becomes law. It is that exceptional, extreme constitutional exception where the president will not have to sign it and pretend to have bill. But it's law. Look, I sat here and I couldn't believe it. I thought I was here for an argument. I haven't seen that. But let me tell you, our police talk about there are no consolidated rule and running here and there. Article 74, if you can get your constitution, it clearly defines that the legislature shall prescribe penalties for contempt. It has not been done under Article 74. But this court, the Supreme Court, in a case titled in Re Francis G. Doe, 23 Liberian Law Report, page 38, the Supreme Court said it is the only sovereign authority that has the inherent constitutional authority to determine what constitutes contempt, even in the face of Article 74. So if I pass in front of the Supreme Court with my hand behind me like that, and one of the justices or judge see me, they can hold me in contempt. So you will say because the legislature has not passed any law to define the penalty for contempt, so the justice presiding or whoever will not be able to impose penalty. There are so many things in the constitutions that we'll speak to. You know, Rule 63 as amended confirms Article 43 due process principle. It took into account the due process rule, Article 28. We charged, the House charged and impeached Justice Janet on 4 counts. 1, the theft of records that were obtained through burglary. He carried out burglary. 2, what did he do? Justice Janet, after stealing the house's record of meanings, was involved with the Annie Constant case. He claimed to have bought the property from Annie Constant's son while the old lady is alive. 3, the road farm case and the petition for prohibition. Now let me dissect in the most sequential order how we were able to proceed to. As a basis, we produced 3 witnesses, 1 direct witness and 2 corroborated witnesses. Akaros Gray was one of the witnesses that we produced. We produced the House Special Light Committee Chair, Councillor Kani Iweso, and Madam Annie Jansen Constant. Akaros Gray appeared and testified that he is a representative of District Number 8 in which Madam Constant resides. And Madam Constant had brought to extension that Justice Janet bought her property from her son without her knowledge. And based on that, he and Representative Thomas Fowler filed a complaint on her behalf to plenary. Plenary received the complaint. As their procedure required, they indicated that this matter to be able to determine the validity or whether or not the mayor committed impeachable offense, the matter should be referred to a committee room. Who should have headed that was the House's Judicial Committee chair. He declined. When he declined, with such a duty and having a strings and other matters before the House that included the Mary Page petition, the road form case, the Anna Constant case, the abuse of the code of conduct, the manner and form in which he was inducted into office, the House then referred to a specialized committee saying the chair had declined. The committee on that day, Tuesday, July 17, 2018, minutes were taken. When the matter went into the committee room, while the matter was in the committee room, Honorable Gray continued, they received information that the minutes for the Tuesday, July 17, 2018 plenary session sitting were not available, were missing. The clerk appeared and said, I don't have the minute, I don't know. A few hours later, Kabineh Mohammed Jammeh, aka Justice Kabineh Mohammed Jammeh, whom I believe is totally unfair to be the Associate Justice of the Supreme Court, filed a petition for a writ of prohibition. Against whom? Against the House of Representatives. What did he do? He attached the records that were missing to his petition. Ladies and gentlemen, if you park your car somewhere and you let the key inside to pick up something, and then you went in, by the time you came, your car is not around, you're looking for your car. 2 days later, somebody brings the car to your place and comes to sell the car or using the car for some purpose. Do you still need further evidence to prove that the person who brought this car is the one who took your car? Of course not. Justice Jammeh petition brought the minutes. He was the one who attached the minutes to his petition. So then the question was, how did he get the minutes? But what was the motive? There was one motive behind it. And that's why the House impeached him for. And that's why you should convict him for. The whole objective was an obstruction of justice. It's an official misconduct. He used, willfully, deliberately, intentionally used the authority of his office to steal the House's record. And the computer in which it was stored, the laptop. And then he attached it, and he called it the public record. But there are procedures on the FOI how you can get records from institutions. And I'll give you one example. If the Supreme Court has deliberated on a matter and a draft opinion is prepared, you go and see the draft opinion and start to circulate, you consider that to be, you say, this is the ruling, this is the ruling. And the Supreme Court should leave you alone and go look for somebody else. But the objective, he had another plan. The reasons why he did that was simply to belittle the House and engage in nothing but smear campaign, and he did that. And his intention was to undermine the authority of the House under Article 43, which vested the power to prepare impeachment bill. The war is prepared. So due process doesn't start there. It's unfair. Absolutely unfair to be associate justice. So I want to tell you, the commencement of due process does not start in the grand jury room. On our criminal procedure law, which Rule 60 recognizes. It begins when the writ of arrest is served, after the grand jury presentment, after the return of a true bill, and then send it over there, and then they issue the writ of arrest. When the person is served and returns served, he comes to court, due process starts, he is asked to enter a plea. That's the law that I learned. Man stole the record, he comes to the play, and he said, oh, and you know, formula trial, and I was not living when formula trial was around, don't care about that. My role is to prove. So, on the issue of the House, of the theft of House record, we have proven. How did we prove it? When you were asked, Mr. Witness, on the stand, how did you get the record? He said, but you already brought me here. Under the principle of omission, the principle of denial, especially it's following the civil procedure law. It's chapter 9, section 9.8, subparagraph 3, they call it failure to deny. What did we do when the Honorable House of Senate set him a rate of summon and he was required under Rule 63.14 and 4 to file his responsive pleading and judicially deny all of the issues there? What did he do? He neglected to do so. And when he was asked a question, he said, you already brought me here. Under international evidence law, we call it the adopted admission principle. Meaning, while I'm on stage, if any woman appears here now and said, he was the one who raped me, when I started laughing, everybody said, oh. But the person there will be a robust defense. He had an opportunity to speak. He remained silent on that. That ground, it carries him. We prove it. He had an opportunity. The next phase is the inconstant case. On the inconstant case, the woman is alive. The woman married in 1940. The boy was born in 1956 when the woman was 31 years old. During the trial, they tried to mislead you by suggesting that she was 63 years old and we have to correct that. The boy was born in 1956. He was legitimate in 1960. In 1996, during the heat of the civil crisis, when April State was around, everybody running enter scandal that when they want to buy property, he's unfit to be associate justice. He bought the property. By what? A single court decree of sale. And in paragraph 3 of that court decree of sale said the board got a letter of administration in 1960. So all I wanted to be that if they can issue the court, the owner interested administration that if they can issue letters of administration, and he wanted to believe it, and associate justice about Supreme Court, the higher court of the land, one gets bothered to believe that an infant can be issued letter of administration. And I'm surprised about women. So cool. And then, here and there. But they didn't deny that. The letter of administration was admitted into evidence together with the meanings of court. And all the things that I'm saying here are contained therein. Convict him on that. Convict him on that. I come to the issue of the road phone case. And this is where I want to speak on. They brought my old man.
Well, that's where he did it. I will give you 5 minutes more or less.
All right. On the road case, let me go back. On the road case. This is an associate justice of our Supreme Court. And my owner and I, Justice Bank, we disagree. And my being is our disagreement, his being was our disagreement. Here is our disagreement. None of them deny that throughout the trial that in 2016 the Road Fund Act was passed. They did not deny that in the 2017 budget it became part of it was captured, the Road Fund was captured. It was law already. More so, those who filed a petition, and I saw too many players here, they calling me. Yeah, I'm surprised because in that one person played 4 roles. One person played 4 roles. Person became a petitioner counsel. Who was the one of the petitioner counsel? My own great friend, Councilor Emmanuel James. Councilor Emmanuel James, who filed a petition, he comes to defend the very person. And you don't see the wrong. You don't see the wrong. Oh. So he went before him and filed a petition. The petition became a subject that deprived the people of Liberia of a legitimate fund to develop the country, to build roads. He followed him to be his lawyer before you. He wants you to free him so that he runs amok and ruin the system. On the cross, it was Senator Yetin who asked me the question, what is the effect of the whole proceeding at the Supreme Court? He said, and I quote, I absolutely left the court naked. It's a naked justice. We should send him back. He said, Unko, they didn't even start there. Justice Banks, in his statement, indicated that at one point in time, he became frustrated and realized that the people representing the government of Liberia were incompetent and stupid. And as a basis of that, he issued the writ. I can show you the statement. It's here in our brief. Okay. Said the words incompetent and stupid. If you made that statement, you certainly can be. You can be an expert witness. Expert witness will go to the depth and character of the facts of the case. More so, Justice Ben played, and that's why I wanted to forgive him. He issued the writ, he placed it in the file, he did not distribute the writ, he left. That was in August. From August to October, he took no further action. And this is annoying me because Justice Janet knew in February 2018 that the government needed money. And so because he wanted to stop the government in pursuit of his personal agenda against the public interest, he went and issued the writ. He's okay. What other evidence do we need to prove? What was the constitutionality of the petition when there was already a budget law or when there was already a reform act? More so, quote me. I have not seen it. I don't know, maybe there's a new way of legislation. But even before the Supreme Court or any court or the RCC, a petition questioning the law must be squarely raised and is titled irreconstitutionality. It's not about a petition for a writ of prohibition. How can the people who were willing agents, Professor Banks said they were contractors of the government, fine. So if there was a dispute of their contract, it would be a dispute relating to their contract. But then, between and amongst the government of Liberia, the importer, and Justice Janet, who actually had a right over the money. The people of Liberia, people of Liberia had right over the money. No Liberian citizen filed a petition to challenge the imposition of the surcharge. The people benefited who were paid 10 cents, who had the money in their possession, were the one that they made the instigator to file a petition to stop the government from building roads. Today, all the roads in the community are at a standstill because of the selfish and greed of individuals in the system. More so, one person played 4 roles. He was petitioner, he was respondent, he became the negotiator, and now the prosecutor. How did he do it? How did he do it? He gave them a waiver, and they were the one that faced the notice of withdrawal and removed the sum of money. And you're serious? The money will remain in your hand, and who will sit down here and just stop, and you'll be just passing around with the money in your back pocket, impeaching, removing. He's unfit to be. He's unfit. We can't run our country like this. We can't. The people of Liberia pay taxes on gasoline products. The people of Liberia were charged. The money is supposed to come. Senator Yala asked a very good question. Wasn't it your responsibility as a national in the interest of the people of Liberia to order an escrow account? It will be the sound discretion of the judge to exercise constitutional power. What kind of constitutional power? You exercise constitutional power at the expense of national interest. I have not seen that. You know, Senator Morai asked a very good question, and I like that. Senator Tiegi, he said, how does it feel when you lose a property? Justice Janet responded, I feel very bad. Oh. So the governor of Liberia should not feel bad when you deny them $27 million to bail. Who they want to feel bad? More so, you came before this proceeding and said, whatever the Supreme Court say, interpretation it provide is the law. In the Annie-Constant case, you say the decision is final. In your case, you say the case is not final. Oh man! Then, more so, the issue of Justice Ben's expertise in constitutional law is baseless. So my own member, I'll carefully use the word. Especially because the question was, he admits that he is not a constitutional lawyer. So constitutional lawyer, you are not a constitutional lawyer, you're not an expert, you are not reading any book, you are not, so you know, I just set it aside. Sorry for using the word basically, let's set it aside. Yeah, there was no need. The man himself said, I have no training. Then what did they do? We show you what they did. They went and defined who is an expert and said it on me. But let me read what the definition, their own definition. Maybe they didn't see it. They said, who is an expert witness that they own something they said for me? Let me read and see. A person qualified by profession, let's say, scientific or technical training, and in regard to a particular subject or field or endeavor. Professor Banks is a seasoned jurist, international jurist, who is respected around the world. But he has never carried himself on being an expert in constitutional law until here. Now, Article 71, one document that Professor Banks had that nobody in Liberia has is for every article in the Constitution, there is a rationale. And let me tell you the story. In 2011, I filed a petition against all the candidates that were running on grounds of the interpretation of Article 52C. My contention then was that the 10-year residency clause was consecutive. Who were the lawyers on the other side? The Honorable Councillor Bani Sharma represented the Unity Party. They said they were consecutive. They said it was accumulated. I said it was consecutive. Professor Ben pressing on the bench provided the direction because he brought the rationale. In the rationale, it stated that it is consecutive and it is not accumulative. Article 71 that he's talking about, and that's why he didn't talk about the rationale here. Because as he talked about the rationale, we'll say, read it. The rationale Article 71 says the first part that has to do with impeachment here and there is solely done by the Liberian Senate. The second part where the conjunction or belongs to what? The court. This man walked into the premises under the cover of darkness, either by agents and procured. Yeah. Okay, Justice Johnny, this accused, who are considered unfit to be associate justice of the Supreme Court, walk under the cover of darkness and deliberately, willfully, and intentionally stole the House's record and comes back here. What message are you sending out? Dozens of our boys and girls are in jail for burglary. Dozens of our boys are in jail for theft of property. Oh, because he's just a Janet, so that will let him go free, while other people will be in jail. A crime is a crime. The housing start there. The house said, look, we've all said and done. Stay away from your position. All you need to do, take pay until the impeachment thing. He defied the house. This is very nice. He said, where's the law? He defied the house. He goes somewhere. Oh, because he's just a Janet, man. Don't stop. Let's be serious. They try as a wise went around the world. They are working by association. As we speak, there are complaints coming against Justice Janet. There are complaints. That man is a source of conflict and riot. I listened to my senior brother talking about a PCA who went to Accra and Justice Janet was one of those who were involved. Please don't make me to remember what happened. How we got to Accra. How some of these people become players in our life. Don't let me to remember that. So the question is, because Justice Janet was involved in peace negotiation in Accra, you want us to go back to Accra? Is that why you see? Oh, is this the objective? Now, I want to close on a few things. What is a writ of prohibition? A writ of prohibition is an order by a superior court to a lower court when it is proceeding by wrong rules. A writ of prohibition is an ancillary action that deals with an interlocutory ruling. Meaning when they say ancillary, it must grow out and need to. It also serves over administrative agencies The man filed premature writ of prohibition against the house when there was nothing was before the court. This is the man that you want to be associate justice.
Councillor Wahina.
You know, he talks about due process. But due process is not within the pale of his actions. This is justice jamming. Sometimes I feel better being a Liberian citizen with the way our people run here. Our friends know the truth, they come here and try to mago the place. Oh, man, we'll go to the place. We'll just say the way of prohibition is this. But I saw at least expected my colleague, Arthur Johnson, he should know. This man abused his office. Oh, man, because he has judicial power. Now, they define, according to them, they say when the petition is filed, the justice presiding in chamber shall. It's not shall, the word is not shall. The word is made, it's discretionary. But because he had a pecuniary interest in the funds that were collected, so he went and issued a way to start road construction in this country. One man, for the country of Bihar hosted, and we said here, he's unfit to be associate justice of the Supreme Court. Starting from today, countless days. Then you go to find a place to sit down. We should be over road. And why are the road on the side of faith? For what? Neither to branch them. And who is refugee? And from refugee. When we ever have road to reach here? Because of somebody's personal gain. So, Your Honor, we want you specifically to Now this is the reliance, the authority of law, or the bodies of law that we have relied upon, for which we said Kabineh Mohammed Janneh, aka Justice Kabineh Mohammed Janneh, is unfit to be associate justice of the Supreme Court, and you should commit him as follows. The string of our argument is Article 43 of the 1986 Constitution. The word is so is vested, is the preparatory power of the House of Representatives on preparing of the impeachment bill. Article 43 makes the House of Representatives the grand jury. The same Article 43 makes the Honorable Liberian Senate the trial jury. Article 71, the first part, refers to the authority of the Honorable Liberian Senate. Of course, the Senate Standing Rule, there are precedents in this jurisdiction under this process. The Senate Standing Rule was used to impeach people in 1987. That rule was amended in 1998, was amended in 2009, and re-amended recently. Now, the provisions of the Senate Standing Rule that we rely upon for all our argument and action are Rule 63.4, 3.7, 3.11. Then we talk about relevance under Title 2, the Civil Procedure Code, 25.4. We have the best evidence principle. Under the best evidence principle, which says the evidence in the case of freedom of all will be produced, we produce all of the pieces of evidence we brought on with Madam Yede, Madam Constant, she said, they met bought my land when I was not in the country. Confirm and affirm what Honorable Kabineh has said. Honorable Wessel came and said the same thing. What did they do? He produced two witnesses, himself and Justice Ben. What did they do? They agreed that when the Supreme Court passes on every issue, it's final. But yet, they challenged the authority of the Supreme Court in determining this matter. Yet, they challenged the authority of the Supreme Court in deciding the case. But in the Constant case, he said everything is right. In the Zuba Bella Basawoni Yamake, he listed the opinion where he says that they not only concur but assign the opinion. He listed the documentation you need, the chain of title, which is the model D, letters of administration, code degree of sale. In the case, I'm only one code degree of sale. When it comes to him, everything that comes to him, it must be exceptional because he's different. He's unfair to be Associate Justice of the Supreme Court. When it comes to Olapo, yes, he doesn't get anybody due process. But he wants due process, he has gotten it. He had an opportunity to confront, to address, and controverse everything we say here. His lawyer cross-examined the witnesses. His lawyer cross-examined our witnesses. But he now didn't start there. Even in cross-examining our witnesses, they started a principle in the Southeast we call the devil principle, where 7 persons are chasing one devil, then again another 7 persons chasing the 7 devil. 7 persons are chasing the one devil. What does he do? The first thing they did, they filed a motion by special appearance, challenging the jurisdiction of this court, of this proceeding. When that was on, they filed a motion for recusal to attack the presiding judge. When that motion was addressed, what did they do? They attacked Aberson and Councillor Sherman in another motion. When that motion was dealt with, they said, well, we will not start there. They attacked me. When that was dealt with, what did they do? They said, we feel everybody now. The next thing we do, let's go to the Senate protector himself. They attack him. You know what was the game plan? To create distraction. And the distractions have been followed around the world that make our system to be a mockery. Marco, you talk about reforming the system. Reforming the system begins with the impeachment of Justice Kabineh and his removal. My friend talks about reforming the system. You cannot reform a system when you have somebody in the system who has become a bull wiggle, eating the crux and fabric of the system, and using the position to compromise national interests for his selfish interests at the expense of the country. Today, nobody can get any information about the collection of the $27 million. Today, all roads throughout the city of Monrovia and other parts of the country are at a standstill because we want to certify one man. If that is the reason why we are called Nigerians, then we need to redefine our course of action. This man must go. When you send a message clear and defined from his removal, all the collaborators and the person who played 4 roles, if I was telling them to call the person in the king and just sat on the knee, one person played 4 roles in this system. Man, how will you impeach him? How you, Minister of Justice, you don't file a petition, how you go and sign a withdrawal? But we'll leave it entirely with you. They signed a schedule of payment regime. That schedule of payment regime has been violated. But in the withdrawal, one of the groups, the current group, insists that streamers should pay. It's part of the group. We admitted that into evidence. They said we will withdraw the action because we want streamers to pay. They get a payment regime. The payment regime they draw up, the very lawyer who filed a petition became the one negotiating with them. So he get a 4 year. I'll leave it with you. Impeaching, removing, so that his collaborators and those who help him to play the system to where they're running the system back, so they understand the message that we are not joking. That this country has to move forward. Let the country move forward. Another one, in closing, I want to say this. Yeah, I'm closing, Your Honor. I'm closing. Professional football player, and one time, Liberia's most celebrated star, James Salim Sadiba, once said, Liberians can only complain where they fall. They do not complain where they stumble. Justice Jammeh and his supporters are complaining that people like us with such a high character are involved in the case. But they forget when they deprive the people of Liberia of the funds to build roads. They forget when they know that when you are alive and your children are around, none of your sons can sell your property. They forgot to know that you, as a public official, you cannot go to another branch of government and steal the records. They forgot to know that you cannot file unduly a petition for road prohibition to obstruct the administration of justice. The independence of the House has to be respected, has to be constitutionally sacrosanct. So as the judiciary, This is a man that wants to remain Associate Justice of the Supreme Court. He walks out. Thank you.
It's a former secretary to the jury, distinguished senators. I think we've been here for about 6 weeks now. About 6 weeks. We've sat, we've listened to the presentations, the witnesses, testimony, and everything. I have consistently maintained that I don't make the decision here. I don't. I was invited to come here and preside. And my role here is based upon the details of the Constitution. In my own mind, I think I've played and will continue to play the role that I'm called upon to play as an impartial referee. To sit down and allow every witness that's in here to be heard. When I determined that the question was not correct, I disallowed it. But for most part, I allowed everybody to be heard. Today, at this moment, we have come to the conclusion of the production of witnesses, lawyers arrested, and you just listened to the arguments that were presented by both sides. The ball is now in your court as the decider of fact. I could not have dismissed this case in my own right. I could not have recused myself because the Constitution says I should preside over an impeachment proceeding when an associate justice is involved. More than that, and I think all lawyers know, most apparently from Mr. Justice Banks, Mr. Justice China, when they testify that a single justice does not decide constitutional issue. That is why when a petition is filed before a justice in chambers, he backs it up and send it to the full bench. So to have requested of me to dismiss a case here, I was challenging the constitutionality of Rule 63 that was promulgated. I felt it was not proper, so I denied it. Now, you will have to retire into your room of deliberation. As eminent citizens who have been elected to this important position, to make decisions, I have no doubt in my mind that you will make a proper decision. Decision you make to serve the interests of our country. In other words, based on what you hear, the evidence has been presented before you, you will decide whether or not an additional offense has been committed in order to make a decision. I know this is not an easy task, but you will need time, you will deliberate, you will talk in a room where you will confine yourself. So we'll give you enough time. As you have listened, we will allow you to go into the room of deliberation and let us know whether you have reached a decision on the matter. I will retire at the Supreme Court after a year, listen out to the Secretary of the Senate, whether or not you have to arrive at a decision. If for any reason you do not arrive at any decision today, we'll convene here tomorrow at 12 noon. In my mind, I think by that time, reasonably, you should have arrived at some decision. So, I implore you, as I know you would, to look at the evidence before you very seriously and make a right decision. So now, we're joined. If there is need for us to reconvene, I hear from the Secretary of the Senate, I will come back. If not, the trial will join to resume tomorrow at 12 o'clock.
Usually in the courtroom where you were threatening the power over the jurors?
Yes, well, the Secretary of the Senate is obvious. They will need the evidence to be able to refer to it as they deliberate. So that is obvious. They put them as the former of the jury will request of the Secretary of the Senate the file so that they can deliberate.
Thank you, and also the inspection of the verdict form.
Councillor,
yes, sir.
These are men and women of eminent quality. I expect that they will follow the law. There is no reason in my mind why they should not. So we leave it, let it come with a verdict. While I join.
The verdict form is
Let's go.
Let's go.